Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibiers? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi, a little under the weather, so bear with me. My voice is all crazy. It gets really low and then it kind of goes out, but we're going to get through these two episodes today. There is a state's response to Charlie Adelson's motion to relinquish jurisdiction to the trial court. So we're going to read through that. Later tonight, I will be going through the Sarah Boone trial, day 2 of testimony. State could rest as early as today, which means tomorrow. She could be on the stand. We'll keep you updated. It's going to be wild. All right, let's get into it. Charles Adelson has filed a motion to relinquish jurisdiction to the trial court in Leon County. While Adelson's motion is unclear as to what specific proceedings he seeks in the trial court below, Adelson appears to be pursuing a claim of ineffective assistance of counsel while his appeal is pending. The state objects to Adelson's motion to relinquish because it is procedurally barred, and Adelson has failed to demonstrate a valid reason to circumvent the normal procedures for post-conviction relief under Florida Rule of Criminal Procedure. The next section is issues presented. Charles Adelson's motion presents 2 issues for this court to consider. First, can Charlie Adelson pursue his conflict of interest claim while his direct appeal is pending? Second, if Adelson can pursue his claim during the pendency of this appeal, should the court exercise its discretion to relinquish jurisdiction to the trial court? The next section is procedural history. A jury convicted Charles Adelson of first-degree murder, conspiracy to commit murder, and solicitation to commit murder. Attorney Daniel Rashbaum represented Charlie during his trial. After Charlie was convicted, his mother, Donna Adelson, was arrested and charged as a co-conspirator in the same murder. After this arrest, Rashbaum represented Donna Adelson in her case. Rashbaum told the trial court that Charlie had waived any conflict of interest that might arise from Rashbaum representing both Charles and Donna. But on the eve of Donna Adelson's murder trial, Charles Adelson rescinded his waiver of conflict of interest. This led Rashbaum to remove himself as Donna Adelson's attorney in her murder trial. Now, Charles Adelson claims that Rashbaum's representation of Donna Adelson infected Charlie's trial. According to Charles Adelson, his case should be relinquished to the trial court for some type of hearing regarding Rashbaum's potential conflict of interest. Adelson relies primarily on State v. Meneses, which said that appellate courts have the discretion to relinquish jurisdiction to a trial court so that a defendant may pursue an ineffective assistance of counsel claim. The state opposes this motion and asks the court to make Adelson follow the normal route of pursuing ineffective assistance of counsel claim. The next section. Adelson's conflict of interest claim should be handled as a post-conviction claim of ineffective assistance of counsel. Adelson's motion fails to explain what he would accomplish by having his case returned to the trial court. Adelson does not allege that a hearing is necessary to establish a claim in this direct appeal. To further the confusion, Adelson's motion does not state that he is moving under any rule of criminal procedure. Instead, Adelson simply quotes old case law where appellate courts have relinquished jurisdiction for a defendant to pursue a claim under Florida Rule of Criminal Procedure. The only plausible ineffective assistance of counsel claim that Adelson could make based on Rashbaum's conflict of interest is an ineffective assistance of counsel claim. The best procedure for handling such a claim is a collateral post-conviction procedure after Adelson's appeal is complete. The next section, Adelson's motion to relinquish fails to satisfy the holding in Steiger versus State, which requires an allegation and showing a fundamental error. Adelson's conflict of interest argument is no more than a premature claim of ineffective assistance of counsel. while Adelson relies on Meneses for the proposition that appellate courts may relinquish jurisdiction to the trial courts so a defendant can pursue an ineffective assistance of counsel claim, the issue in Meneses was a Brady violation, not an ineffective assistance of counsel. The Supreme Court of Florida's decision in Steiger versus State cast doubt on whether Adelson can still rely on Meneses to obtain a mid appeal hearing on an ineffective assistance claim. 40 years after Meneses was decided, the Steiger court held that ineffective assistance of counsel claims may only be raised on direct appeal in the context of a fundamental error argument. The Steiger court also held that a post-conviction proceeding is the proper vehicle for ineffective assistance claims under Strickland versus Washington. It says ineffective assistance of counsel claims relying upon the less demanding Strickland standard are properly considered upon the filing of a legally sufficient post-conviction motion in the trial court. At a minimum, Steiger narrows the holding in Meneses by severely limiting the ineffective assistance of counsel claims that may be raised on direct appeal. Adelson's motion to relinquish fails to meet the requirements of Steiger because the motion does not allege fundamental error. To establish fundamental error, Adelson must demonstrate an error that reached down into the validity of the trial itself to the extent that a verdict of guilty could not have been obtained without the assistance of the alleged error. Thus, if Adelson wishes to bring an ineffective assistance of counsel claim on direct appeal, he must allege and demonstrate that Rashbaum's conflict of interest caused the jury to convict Charles Adelson rather than acquit him. Adelson's motion to relinquish fails to allege or demonstrate that Rashbaum's conflict changed the jury's verdict. Instead, the motion merely claims that Rashbaum's conflict of interest infected Charlie's trial. The Florida Supreme Court's decision in Steiger makes it clear that this allegation of infection is insufficient to warrant the relief Adelson seeks under Meneses. At best, Adelson's claim that Rashbaum's conflict infected Charlie's trial alleges a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. They cite Strickland versus Washington. The Steiger decision requires Adelson to raise the Strickland claim in a collateral post-conviction motion. Next section. This court should refuse to exercise discretion to relinquish jurisdiction. The Meneses court made clear that an appellate court's authority to relinquish jurisdiction is discretionary. Meneses held that the filing in the appellate court of a request to relinquish jurisdiction, however, does not require an appellate court to automatically relinquish jurisdiction to the trial court. The Meneses court also noted that the appellate court, before relinquishing jurisdiction, may evaluate the grounds for the motion to vacate to determine whether they are frivolous and may decide not to relinquish on this basis. Adelson's grounds are speculative and therefore frivolous. Even if this court could relinquish jurisdiction under Meneses, Adelson has given this court no reason to do so. Adelson's motion provides this court with no blueprint for how his case would proceed if placed back in the trial court. At a minimum, Adelson's motion should have demonstrated two things. First, that further proceedings in the trial court will reveal that Rashbaum had an actual conflict of interest. Second, Adelson should explain why his conflict of interest claim would not be better addressed in a post-conviction motion. Because Adelson did not raise his conflict of interest claim in the trial court, Adelson cannot raise Rashbaum's conflict of interest on direct appeal unless Rashbaum had an actual conflict of interest. They cite some case law. It says, in order to establish a violation of the Sixth Amendment, a defendant who raised no objection at trial must demonstrate that an actual conflict of interest adversely affected his lawyer's performance. An actual conflict of interest means precisely a conflict that affected counsel's performance as opposed to a mere theoretical division of loyalties. Adelson's motion is insufficient because it cites the possibility of a conflict of interest, but does not hint at how conflict prejudiced the outcome of his case. But the possibility of a conflict is insufficient to dispute a criminal conviction. The Supreme Court explained the reason for this and how even a trial court's awareness of a potential conflict is insufficient for a Sixth Amendment violation. They quote a case, Mickens. It says, the trial court's awareness of a potential conflict neither renders it more likely that a counsel's performance was significantly affected, nor in any other way renders this verdict unreliable. In fact, a potential conflict can work to a defendant's advantage by ensuring that a jointly represented co-defendant does not cooperate with law enforcement, and they cite Dixon versus State. Such joint representation may provide a common defense that gives strength against a common attack. The facts alleged in Adelson's motion are insufficient to even support an ineffective assistance of counsel claim until a defendant shows that his counsel actively represented conflicting interests. He has not established the constitutional procedure for his claim of ineffective assistance. The Florida Supreme Court in State versus Alexis held that showing an effect on counsel's performance is essential to showing an actual conflict of interest. A theoretical conflict is almost always present in cases of multiple representation. At best, Adelson alleges a theoretical conflict of interest that would be better explored through the normal post-conviction claim process. This would allow the lower court to hold a hearing on all of Adelson's post-conviction claims at once. The record contained in Adelson's own appendix shows why Adelson's conflict argument is premature, and therefore his motion should be denied. Both Charlie and Donna waived any conflict arising from Rashbaum representing both co-defendants during separate trials. But before jury selection in Donna's case, Charlie revoked his waiver of the potential conflict. During that jury selection, attorney Laurel Niles, Charlie's appellate attorney, stated that when they received subpoena for Charlie's trial testimony, they spoke to him about invoking his rights. Niles recognized that a potential conflict would only arise if Charlie took the stand as a state witness and faced cross-examination from Donna's attorney, particularly Rashbaum. Niles stated that the potential for conflict was always there, but the conflict arose and it's going to arise on the witness stand. It has not quite arisen yet, but potential for conflict is there. Thus, even during the hearing, which resulted in attorney Rashbaum's removal from Donna's case, Charlie recognized there was a potential for conflict if he testified, but Charlie did not assert that there was an actual conflict. In his motion to relinquish jurisdiction, Charlie appears to rely on the fact that both the state and Rashbaum listed Donna as a witness for Charlie's trial. Rashbaum, however, removed Donna from the witness list before Charlie's trial began. Charlie's motion speculates that Donna's removal from the witness list was done in order to protect Donna's interest, which is not being interviewed by the state, and against Charlie's interest, meaning a witness that could have corroborated Charlie's testimony was not called by Mr. Rashbaum. This speculative claim is a poor reason to put this appeal on hold and send Charlie's case back to the trial court. Charlie cites an October 12th, 2023 motion hearing where an attorney on behalf of Donna, who was then a potential witness in Charlie's trial alongside her husband Harvey, her attorney had concerns about the state seeking to interview Donna and Harvey. Rashbaum, then representing Charlie, explained to the court that he had included Donna on his witness list after the state had sought to interview her. Attorney Rashbaum believed the state had sought to interview Donna as an end run around the discovery rule. Rashbaum complained the state had years to interview Donna Adelson, but only sought an interview immediately before trial. Rashbaum stated that he would remove Donna from the witness list if she was not going to be interviewed, But Rashbaum added that he listed Donna as a witness as a protection for myself to put them on there. The court asked if anyone was planning on calling Donna, and Rashbaum explained he did not intend on calling Donna Adelson. Rashbaum further accused the state of gamemanship, claiming that the state did not intend on calling Donna, but instead they were trying to get an interview now on the eve of the trial, frankly, to figure out what my defense is. The prosecutor, Ms. Kappelman, responded to Rashbaum's accusations, stating that Donna and Harvey had never made themselves available for an interview. Kappelman said that she reached out to the Adelsons to nail down the fact that they were going to invoke their Fifth Amendment right against self-incrimination. Donna responded she was going to invoke the Fifth for pretrial purposes, but not for trial. This response led Kappelman to believe that the Adelsons were going to testify for the defense. Kappelman stated she was seeking to interview Donna and Harvey prior to trial to see if they were going to invoke, but she did not know if she would call them because they never made a statement. Therefore, the parties stipulated that neither the state nor defense would call Donna or Harvey as a witness. Thus, the record shows that Rashbaum did not remove Donna from the witness list to protect her interest and thereby undermine Charlie's defense. In fact, attorney Rashbaum had never intended on calling Donna Adelson as a witness. Instead, Rashbaum only listed Donna as a defense witness when he learned the state was intending on interviewing her. Rashbaum believed that the state was attempting to avoid discovery and gain insight into Charlie's defense. These facts fail to show that attorney Rashbaum changed his defense strategy to benefit Donna to the detriment of Charlie. And even if Rashbaum had intended on calling Donna as a witness, there would only be a conflict if Donna's defense was detrimental to Charlie's case. There is no evidence of that. Rashbaum's representation of both Donna and Charlie was no more conflicted than the dual representation at issue in State versus Alexis. Alexis and co-defendant were represented by the same attorney at trial. The victim and another witness testified that Alexis or the other co-defendant had pulled the victim out of a car and pointed a gun at him. The co-defendant made a statement at trial that both he and Alexis asked the victim to get out of the car, which was occupied by a female friend of theirs, and Alexis had pulled him out of the car. Both defendants testified at trial that they had jointly pulled the victim out of the car, but neither displayed a gun during the encounter. The state had argued that since the co-defendants' respective defenses were compatible rather than conflicting, they both admitted pulling the victim from the car, they both denied being armed, and neither claimed the other was armed. The dual representation did not create a conflict of interest between respondent and his attorney. The Florida Supreme Court agreed there was no actual conflict of interest. The conclusion: there is no reason to delay this appeal any longer. If Mr. Adelson wants to immediately pursue his post-conviction remedies, Charlie Adelson should dismiss this direct appeal. If Adelson does not immediately want to pursue the post-conviction claims, he should continue with this direct appeal and file his post-conviction motion when this appeal concludes. The state asked this court to deny Adelson's motion to relinquish jurisdiction, and this is from the Attorney General's office. So that's it. I will be doing another episode tonight on the recap of Sarah Boone Day 2 testimony. A lot of it revolves around the body cam video the day of, as well as her sit-down interview with law enforcement the next day. We will go through that, and I will see you soon.